Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required anytime the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Welcome back to Liberty Trigger. If you believe in the Constitution, if you believe in accountability, and if you believe that judges should actually know the law before they're given lifetime appointments to interpret it, then buckle up, because what I'm about to show you is nothing short of outrageous.
Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
but
Senator.
that's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say this group, we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
could. Tell me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
when can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal constitution.
Okay, good. Judge, tell me about the Privileges and Immunities Clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, 4th. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You telling me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
but you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the Privileges or Immunities Clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
Privileges are immunities.
yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that
Okay.
far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer that
Chairman.
briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing
it. It prohibits discriminating on the basis of race or color or national origin under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people.
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator.
That was Senator John Kennedy from Louisiana, one of the last remaining straight shooters in Congress, doing what he does best, asking simple, straightforward constitutional questions to President Biden's judicial nominees, and guess what? They couldn't answer. You heard it. The basic stuff, Fourth Amendment, warrant requirements, exceptions to those requirements, Supremacy Clause, Privileges and Immunities, Title VI of the Civil Rights Act. These aren't trick questions, folks. This is day one law school material. And these people want to be federal judges. Let's break this down like real Americans who still care about this country. Judge Dudek, when asked about when a warrant is required, fumbled. Then Kennedy tosses a softball. What if Florida decided to eliminate exceptions to the warrant rule? Her answer? Confused. She contradicts herself within 2 minutes. First says Florida can't do it, then agrees they can under their state constitution. Folks, we're talking about the Supremacy Clause and the principle of adequate and independent state grounds. And she didn't seem to grasp it. Change your answer? You're applying for a federal bench and can't even stick to one legal principle? That's terrifying. Then comes Judge Pratt. Senator Kennedy asks a very reasonable question. Can a state legislature discriminate against one group over another? Again, it's not a gotcha. The answer should be crystal clear. Only if it doesn't violate the Equal Protection Clause or any protected class. But no, she gives a meandering example about driving ages and can't articulate a firm constitutional boundary. And then, oh, this is the kicker. Senator Kennedy brings up the Privileges and Immunities Clause. Now, if you're a judge, you should know where that is, what it does, and how it fits into federalism. 13th Amendment? That's the amendment that abolished slavery. The Privileges and Immunities Clause is in Article 4. It protects citizens' rights as they travel across states. And she didn't know that. Let me say that again. A sitting judge, who's being considered for a lifetime federal position, didn't know one of the core components of the Constitution. That's not just embarrassing. That's dangerous. And then, oh yes, it gets worse. Senator Kennedy asked another nominee, Judge Arto, about Title VI of the Civil Rights Act of 1964. You'd think someone who wants to sit on a federal bench would know this one like the back of their hand. Title VI prohibits discrimination based on race, color, or national origin in programs receiving federal financial assistance. But listen to this mess. It ensures equality, not discriminated services. I believe it's under the Commerce Clause. What? No. Title VI applies only when federal funds are involved. This is first-year civil rights law. And yet, they had no idea. Now, let me tell you what this really means. This is not just about a few judges stumbling over legal jargon. This is about ideologically driven nominees being rushed through by the Biden administration. Nominees who are more committed to a political agenda than to the Constitution they swore to uphold. They're not chosen for their knowledge of the law. They're chosen because they check boxes. And that, patriots, is how you destroy a republic from the bench. So what do? We stay loud. We demand qualified judges, not activists in robes. We support senators like John Kennedy, who still believe in the rule of law. And we vote like our Constitution depends on it, because it does. If you're as outraged as I am, hit that like button, share this video with every Constitution-loving American you know, and don't forget to subscribe for more truth the mainstream media won't show you. This is Liberty Trigger, and we're not backing down. God bless America.